European Union law at Masaryk University, but she is also one of the leading members of the Center for Judicial Cooperation and of the Trial Project. So Maddalena, the floor is yours to introduce and moderate our dialogue titled "To Trust or Not to Trust, Virtues and Vices of the Court of Justice Approach and the Challenges for Judicial Cooperation."
Thank you, Nicole, for the kind introduction. And of course, it is my honor to moderate the panel that you entitled Trust or Not to Trust, Virtues and Vices of the European Court of Justice Approach and the Challenges for Judicial Cooperation. So the main purpose, I would say, of this panel is to discuss potential solutions to the challenges of applying the ECJ jurisprudence that has so far shaped the principle of mutual trust. And for this purpose, we have invited three distinguished speakers, three judges who have found, I would say, different but also complementary ways to reconcile what are occasionally conflicting objectives, that is mutual trust and the respect of the rule of law, conform interpretation with Dublin III regulation, and the respect of the EU Charter of Fundamental Rights. So the discussion of this panel will concentrate on three topical issues. Three questions that I will pose to the speakers, and that is, what is the precise test that a national judicial authority has to follow when deciding whether to transfer or not an asylum seeker in a member state responsible for processing the asylum application? Secondly, how do national judicial authorities assess information on the asylum proceedings and reception condition in the member state of transfer for the purpose of establishing whether there is or not a risk of violation of a fundamental right? And third issue is connected to what Marcella has already pointed out in the final slide of her presentation, and that is, should indirect refoulement also be considered a bar to mutual recognition? On which legal basis under the Dublin III regulation, and which authority actually bears the burden of assessment? So without further ado, I'll immediately give the floor to our first speaker, Judge Bostian Zalar, who is a judge at the Administrative Court of Slovenia, but he's also the president of the European Charter of the International Association of Refugee and Migration Judges. And I kindly ask Bostian to stay within the 15 minutes time limit for the presentation. And also, of course, this kind request is addressed to all the speakers because I very much want to ensure that we have sufficient time for question and answers from the participants. So without further ado, Bostian, the floor is yours.
Thank you, Maddalena. Good afternoon. Thank you also, Nicole, for inviting me to this intellectual exercise on mutual trust. My intervention as being a judge will be complementary to what Marcella Ferri had just explained from the perspective of an academic. Although a careful listener might find some differences in our interpretations of the EU law, and I will try to answer all three questions together. Based on my judicial experiences, I would say that mutual trust has different modalities depending on the concrete legal provisions in the EU law which activate mutual trust, and depending on the particular human right which is at stake. For example, the Slovenian case of Detiček back from 2009 related to a matrimonial dispute between the Italian father and Slovenian mother over the custody of their child. And here the mutual trust was determined by several provisions in the EU regulation. For example, Article 3 of EU regulation on matrimonial disputes explicitly says that under no circumstances may a judgment of a member state be reviewed as to its substance by another member state. In contrast to the teacher case, mutual trust had a different modality in the case of Meloni. Meloni case relates to the framework decision on the European arrest warrant and the right to defense. The framework decision has a similar provision as the Dublin regulation in the field of asylum. Namely, Article 1, Paragraph 3 of the framework decision states that the decision on a European arrest warrant must respect fundamental rights as enshrined in Article 6 of the treaty. But fundamental right to defense from the Charter did not play a significant role in the Meloni case. The Luxembourg Court decided that the Spanish courts cannot use a particular element from the Spanish constitutional law on the right to defense because framework decision provides an exhaustive list of the circumstances in which the execution of arrest warrant does not infringe the rights of the defense. However, in the French case Jeremy F., the legal situation and the outcome of the case was different. The very same framework decision has no express provision on the possibility of a right to appeal with a suspensive effect against a decision to execute an European arrest warrant. Therefore, in contrast to Meloni in Jeremy F. case, the French court were allowed to use domestic constitutional standards on suspensive effect, provided that this will not jeopardize time limits set in the framework decision. Now, in both cases, Meloni and Jeremy F., mutual trust was defined as a principle under which national legal systems are capable of providing equivalent and effective protection of fundamental rights recognized at the European Union level, particularly in the Charter. The protected value behind both Meloni and Jeremy F. cases was the principle of the primacy of EU law, and this is important for the understanding of mutual trust in the field of asylum. Under the circumstances that there is no discretionary clause in place, because there is a very relevant difference between mutual trust under framework decision and mutual trust under the Dublin regulation. The framework decision does not have a discretionary clause. In asylum cases NS and ME and CK and others versus Slovenia, the Luxembourg court stated that discretionary power conferred on the member states forms part of the mechanisms for determining the member states responsible for an asylum application. And this is extremely important to emphasize, particularly from the perspective of prospects for effective protection of derogable rights, that is, non-absolute rights. Then there is for example, the Latvian case of Petruchin, which relates to the issue of mutual trust in the field of extradition to EU citizens to a third country. Here again, the modality of mutual trust was a subject of the very concrete legal provision. In Petruchin, this was the protection against discrimination based on nationality and the freedom of movement under the treaty provisions. So what do Aragnosi and Calderaro and, for example, Dorobantu judgments add to the understanding of mutual trust in the field of asylum? These cases are about the prison conditions in Romania, and the referring German court simply wanted to provide an effective judicial protection against inhuman and degrading treatment, because the German courts were aware of several systemic judgments of the Strasbourg court against Romania. I see no special difficulty in the two-step test developed by the Luxembourg court. In asylum disputes, we constantly obtain and use objective, reliable, specific, and properly updated country information in relation to third countries, but also in relation to the border EU countries. In court proceedings in Slovenia, we use those information ex officio, if necessary, because of Article 46, Paragraph 3 of the Procedures Directive, or based on Article 47 of the Charter, of course, taking into account also the case of the Strasbourg Court. The so-called second step, which is to check whether that particular applicant could suffer violation of Article 4 of the Charter, is also reasonable and feasible, since under the framework decision, the executing authority of the member state can easily communicate directly with the authority of the issuing member state in order to get full information and assurance that the applicant would not suffer violation of his right from Article 4 of the Charter. And this should be the same in asylum and asylum-related disputes in the context of mutual trust. In my view and in our practice, this communication must be conducted by the administrative authority. The burden of proof is on the Ministry of Interior. This is clearly stated in preliminary ruling in CK and others versus Slovenia, but also, in my opinion, in LP case on the European arrest warrant. However, I agree that the two-steps test is less feasible in case of doubts about judicial independence under the circumstances of mutual trust from the LM case, because it is hard to check whether the system of appointment of judges, disciplinary procedure, performance evaluation of judges, rules related to the Code of Judicial Ethics implemented by Judicial Council of the respective member state will decisively and negatively impact the independence of adjudication in a concrete judicial proceedings. Taking into account also the so-called contextual approach, if I may use the expression of President Lennartz. On the issue of evaluation of judicial independence, obviously the Luxembourg Court wanted to give priority to the political process at the level of EU, instead of giving a considerable power to judicial authorities of the member state. But as a judge of a national court, I should not make things more complicated as they are. My role is to provide an effective judicial protection of rights and obligations of persons and to simplify or reduce the complexity of this interplay between EU law, European Convention on Human Rights, and national law in a transparent and workable manner as much as possible. Let us not forget that according to the recent case law of the Luxembourg and the Strasbourg Court, it is not just judicial independence which is the essence of fair trial. The essence of fair trial from Article 6 of the European Convention, or the essence of Article 19 of the Treaty of the European Union, is also the right to be judged by the court established by law. The Luxembourg Court in Simpson case made a concrete reference to the small chamber judgment in the case of Astrason versus Iceland. So I would probably use the same methodology as the Grand Chamber of the Strasbourg Court did in the case of Astrason in December 2020, in conjunction with few paragraphs from the case law of the Luxembourg Court in relation to the question whether the court of another member state is established by law. However, until we get a more concrete and reliable checklist on judicial independence from the Luxembourg Court, my approach to the two-steps judicial test might structurally and broadly speaking follow the methodology of the Luxembourg Court, but basically it will be pretty much the same test as it was developed by the Strasbourg Court in MSS judgment. So in this sense, that would be my relaxation of the so-called double step test, to use the words of Nicole in her introduction. I should mention that the framework decision on European arrest warrant has a particular provision which cannot be found in the Dublin regulation. Recital 10 of the framework decision states that the implementation of the mechanism of the European arrest warrant may be suspended only in the event of the serious and persistent breach by one of the member states of the principle referred to in Article 2 of the treaty, and in accordance with the procedure provided for in Article 7 of the treaty. So this provision makes the concept of systemic deficiency a kind of a terminus technicus, with a very concrete legal meaning and consequences. In contrast to these, I do not take the term systemic deficiency under the Dublin regulation as being a terminus technicus, and I will explain this in a minute. But before that, let me stress one thing of evidence law, which is not mentioned in CK and others versus Slovenia, nor in the case of Javo, but it is very important. The aforementioned rules and standards on two-steps test on mutual trust are not activated only if there are substantial grounds to believe that the applicant will run a real risk of being subject to inhuman treatment. standards on strict scrutiny are activated already if the applicant has an arguable claim in relation to Article 4 of the Charter, meaning that his claim does not appear to be manifestly unfounded. With my final remark, I will answer the third question that the organizer asked me to address, and that is, how should judges protect the risk of Article 4 of the Charter, either through the extensive application of Article 3, Paragraph 2 of the Dublin Regulation and beyond the requirements of systemic deficiency, or through the application of discretionary clause? Well, both options are legally possible, but the first one is, in my opinion, less contentious. For the first option, it is relevant to establish that what exactly is the origin of the legal concept of systemic deficiency in Article 3 of the Dublin Regulation. In some sense, everything started as a kind of a fake news. Namely, it is wrong to say that the origin of systemic deficiency is in the judgment of the Grand Chamber in the case of MSS versus Belgium and Greece of the Strasbourg Court. Namely, after MSS judgment, the small chamber formations of the Strasbourg Court in admissibility decisions wrongly interpreted MSS, because in MSS the Grand Chamber did not use the argument of systemic deficiency at all. Nevertheless, small chamber judgment that followed MSS in cases against Netherlands, Austria, and Italy started to use the systemic deficiency as the necessary conditions for the protection of Article 3, which was a false interpretation of MSS. It is true that at the end of 2011, the Luxembourg Court in NS and ME used the term systemic deficiency, but the Luxembourg Court did not say clearly that systemic deficiency is a necessary requirement for the protection of inhuman treatment. In the next step, the small chamber of the Luxembourg Court too misinterpreted these developments by saying in Abdullahi case from December 2013 that the only way in which the applicant can call into question the choice of the particular criterion from the Dublin Regulation is by pleading systemic deficiency. So that is how this legal concept came into Dublin Regulation 2013, by mistake. After Grand Chamber judgment of the Strasbourg Court in Tarakel versus Switzerland in September 2014, and after CK and others versus Slovenia from February 2017, I believe it became clear to all that systemic deficiency is not a requirement that is necessary in order to activate protection of Article 4 of the Charter, since this is an absolute right. So based on NS and ME, a systemic deficiency only means that any infringement of a fundamental right whatsoever, the slightest infringement of EU directives, cannot be sufficient to prevent the transfer of an asylum seeker to the member state primarily responsible, and that the relevant test is whether state authorities knew or ought to have known about the serious conditions in another member state. So systemic deficiency is not terminus technicus under Dublin Regulation. Therefore, the threshold under Article 3, Paragraph 2 of the Dublin Regulation can be established, and this article can be used without prior establishment of the systemic deficiency. And this is what the Luxembourg Court actually says in paragraphs 91 to 94 of the CK Others versus Slovenia. And also careful reading is needed of paragraphs 73, 74, and 88 of the CK and Others. As regards the discretionary clause in Article 17 of the Dublin Regulation, it may be used for eventual protection of other fundamental rights, such as the best interest of the child and protection of private life of applicants, in order to avoid conflict between EU law and European Convention of Human Rights. Discretionary clause, from the standpoint of EU law, cannot become an obligation, but from the standpoint of national law and the European Convention of Human Rights, discretion may evolve into an obligation. I thank you very much for your attention.
Thank you very much, Bostian, for your presentation. It's definitely a welcome parallel with the European arrest warrant. and the Dublin III regulation. So without further ado, I'd like to give the floor to our next speaker, Judge Luca Perilli. He's a judge at the Court of Milan, and we will hear now more insights in regard to the three topical questions from the perspective of Italian jurisprudence. Luca, the floor is yours, and please try to stay within the 15 minutes time limit. Thank you. Luca, I cannot hear you. Perhaps if you could unmute. I can see only the PowerPoint slides.
Okay, can you hear me now?
Yes, now it's good.
Do you see the presentation?
Yes, I do.
I can start. So thank you very much. So in my court, we have recognized the relevance of a case of an indirect refoulement in the context of Dublin. It was a case related to an Afghan citizen. However, I want to make it immediately clear that it's not possible to a fresh re-examination of the case, because judges in Dublin context don't have cases issued by other judges. So it's really impossible, because we have only one order of transfer, but not the case that has been already decided by another judge. So what we consider, and this is part of my presentation, is only the consequence of the exhaustion of the internal remedies. But what is really relevant for us, like in that case, is the refoulement in itself. And from my point of view, it is not relevant discussing of direct or indirect refoulement, because this is a consequence of the asylum system, as the court said in Iawo, and as Professor Ferri said before. Very short, the cases are the cases that have already been mentioned. So NS 2011, CK 2017, Iawo 2019, and Aragnosi and Caldararo, because this is part of the question that have been received by Nicole. And 2016, 3 of them are Grand Chamber decision, except CK. When we try to apply the case law of the court to find the key of this new case law of the court and to apply in our system, we have always to have in mind the aims and the objectives of the Dublin system. So on one side, this is my reading, rapid processing of application for international protection, and on the other side, limiting secondary movement, which is a political aim, whether we share it or not. And the ground, as you said, is mutual trust. In the previous regulation, 2003, the fundamental rights are basically absent, mentioned only twice, and humanitarian clause 3 times. There was no special rules on applicants' legal safeguards, and the transfer decision might be subject to an appeal or a review, but not to an effective remedy. What changed is when the court in NS, and then repeated in CK and Iawo, said that the transfer decision within the Dublin context falls within the EU law, is implementation of EU law that triggers the Charter of Fundamental Rights according to Article 2051. And then we have the fundamental rights in the system. And regarding the fundamental rights, we have to take into account 3 different aspects. And this is very relevant for the judge, because all of them are relevant for the judge and for the role of the judge. First of all, that the aim of rapid processing of application is now strictly connected with the effective access to the procedure, whereas 4 and 5. And this is also in the procedure directives. So rapidity, but also guarantees. Second point, legal safeguards. So in our claims, we always or very often find a claim related to the violation of the right of information, Article 4 and 5. We don't have time to explore this, but it's very relevant. And, which is new, the effective remedy in compliance with Article 47 of the Charter. In establishing an effective remedy, the judge has to take into account not only the legal but also the factual situation in the member state. So we, as judges, consider facts, and what is relevant for us are facts. So there is no fresh examination of the case, but there are facts which are different from the facts examined into the case that we normally don't know. Final point, the judge has to take into account not only the charter, but also the relevant case law of the European Court of Human Rights, whereas 32 and 39. Now, we know already NS. Let me just summarize shortly. So first of all, presumption of equivalent protection of fundamental rights by the member states. However, second passage, in practice, it might be not true that it's possible that the person is treated in a manner which is incompatible with the fundamental rights here mentioned in general, all fundamental rights. The third passage is that the presumption is not irrebuttable, but can be rebutted in order to make the transfer compatible with the interpretation of the framework of fundamental rights by the judge. The conclusion is that person might not be transferred in case the person ran the risk of inhuman and degraded treatment, namely in NS, stemming from systemic deficiencies. So NS, systemic deficiencies. And this is then the text that we know of Article 3.2. But what is relevant to me is to highlight in Article 3.2 the remedy. So Article 3.2 has not only the rule, but also the remedy. The remedy is where the transfer cannot be made pursuant to the regulation, the determining member state shall become the member state responsible for the examination of the claim of international protection. This is the remedy, and this is foreseen specifically by the regulation. Then, in the question made by Nicolis said, but the Court of Justice mentioned Aragnosi and Calderaro many times, both in CK and Yawo, in both decisions, not only in Yawo. 4 times, but never with reference to the test, the double test of first systemic and then individual, never. Aragnosi is mentioned in a different context. First of all, to remark again the principle of mutual trust and equivalent protection of fundamental rights, save in exceptional circumstances. Please consider this point, exceptional circumstances. So this is an exception. Second passage, Article 4 has a general and absolute character, which prohibits, without any possibility of derogation, inhuman and degrading treatment. So the focus is on the absolute and general character of Article 4. This is the point. Then, what is the consequence in the 2 decisions? In Yawo, the consequence is that having information that is objective, reliable, specific, and properly updated, not only systemic or generalized deficiencies are relevant, but also deficiencies which might affect certain groups of people. So we are already in an individual context, which is even more clear in CK, that was a personal situation of the applicant, because in this case, the court said that is relevant what? The consequence that stem from the execution of the decision for that person that might lead to inhuman and degraded treatment. So individual consideration. So what does Aragnosi and Calderaro means when mentioned by the court in CK and Yawo? From my point of view, it means this, that the forced transfer of a person, like in the case of a European arrest warrant, might lead to the violation of her individual fundamental rights. In this case, courts are under an obligation to assess the legality of the decision to transfer, since the execution may lead to inhuman and degrading treatment. I repeat it, it is the execution of the decision. So it is the consequence of the system. Then it is clearly said, as Bastian has anticipated me both in CK and Yawo this, because in CK the Commission's argument according to which Article 3.2 should be relevant only in systemic deficiencies, has been found unfounded by the Court of Justice, that said that nothing in the wording of that provision suggests that the intention of the EU legislator had been to regulate any circumstance other than of systemic flows, preventing any transfer of asylum seeker. And again, it is repeated that when there is a real and proven risk of inhuman or degrading treatment, this is a matter of fact, real and proven risk. We can have an exceptional situation in which the transfer can be suspended, blocked. Otherwise, the interpretation would be incompatible with the absolute character of Article 4 and would run against the Charter of Fundamental Rights. Similarly clear is in Yawo. Although the second subparagraph of 3.2 envisages only the situation underlying the judgment of systemic flows, nevertheless, it is also relevant. A transfer that might bring to inhuman and degrading treatment for the person during his transfer or thereafter. So at the very moment of the transfer, during the asylum procedure or following it. So we have to consider also the consequences of the asylum procedure. And when we evaluate the refoulement, whether direct or indirect, we evaluate the consequences, not the content of the decision of a different judge that we don't know. Then we have the threshold, particularly high level of severity already mentioned that we find in Yawo. In our case, Afghan, what was the threshold? The threshold is factual situation. So we found out using accredited sources of information that thanks to a cooperation agreement between Germany and Afghans are returned regularly to Afghanistan. And Afghanistan is a country which is at the first place in the war index elaborated at international level. The fact is the high risk of being returned is not the content of the decision adopted by the German judge that we don't know. Article 17 is a remedy in this case. In CK, the court was very clear. Article 17, read in the light of Article 4 of the Charter, cannot be interpreted as requiring the member state to apply the clause. So Article 17 is not part of the Dublin system. It's a discretionary possibility for the state to decide whether to apply it in line with the convention or in line with the constitution, but it's not part of the Dublin system. The only remedy is Article 3.2, the only remedy existing in the regulation. Where the transfer cannot be made pursuant to this paragraph, the determining member state shall become the member state responsible. Conclusions. Article 4 has a general and absolute character. An effective remedy implies that a judge must prevent the transfer in any case of risk of infringement of Article 4, even in the absence of systemic flaws, individual cases. Second point, Article 4 can be infringed by the execution of transfer, during the transfer or thereafter. The consequence is relevant. Refoulement, direct or indirect, that put at risk of infringement of Article 4 is always relevant. Ilias and Ahmed versus Hungary is already part of the European case law. The judge of the effective remedy must assess not only the legal but also the factual situation of the return. Third point, and final, the deviation from the mutual trust is an exceptional condition. A particularly high level of severity of the violation is needed, and this is a fact that the judge has to establish. No different violation of human rights are relevant in the context of Dublin regulation. Article 17 is a free choice of the concerned state. It is a derogation. 17 is a derogation. It is not an exception. Thank you for your attention.
Thank you very much, Luca, for your presentation. I think you've very well clarified one of the most challenging strands of jurisprudence of the European Court of Human Rights and the European Court of Justice. But I would say this is one of the views, or particular a view that was approached also by the Court of Milan and has followed in regard to the interpretation of indirect refoulement. But there's also perhaps another view of how to interpret and how to deal with judicial disagreement. And for this different or alternative view, I'll give the floor to our next speaker, Judge Luca Miniti, who's a judge at the Court of Florence, and who has been the author of a very recent request for preliminary ruling asking the European Court of Justice on how to interpret indirect refoulement and whether this can be considered a bar to the principle of mutual recognition. So without further ado, I'll give the floor to Luca, and of course, kindly ask you to stay within the 15 minutes time limit. So far, we're doing good, but I hope to have at least a few minutes for questions and answers. Luca, the floor is yours.
Please, Luca, you should unmute. You're still muted.
Okay. Thank you, all of you, and Marcello Ferri and Nicola Zerini. First of all, the picture drawn by you, all of you, make me easier, make easier to explain my point of view. You know that I titled my short speech "To Trust or Not to Trust," and which trust? Which trust in case of risk of indirect refoulement? Which trust? I don't think that we have to choose not to trust, trust or not to trust. We have to choose which trust we choose. You know that in April and in May 2021, two requests for a preliminary ruling were issued by the Court of Rome and Court of Florence in Italy, both concerning the issue of indirect refoulement under the Dublin Third. My short speech moves from Florence's case to describe the differences between the two decisions and to suggest the solution that, in my view, the Court of Justice should endorse. Should endorse if the Court of Justice doesn't agree with Luca Perilli, of course, because the way chosen by Luca Perilli cut every problem I explained you. The primary question concerned the possibility, according to Article 17 of Dublin Third, or the duty, according to Article 3, as Lucas Perilli said, of a member state different from the member state primarily designated as responsible under the same regulation, to assert its competence, the competence, administrative competence, and obviously, I say, judicial competence according to Article 27, to decide the asylum claim when the asylum seeker is likely to be deported. Luca has been very clear about this. When the seeker is likely to be deported to his country of origin, we are in front of a fact where he would run a real risk of inhuman or degrading treatment, not only in the case of personal condition, case IAVO, etc., or in case of systemic flaws, but in the case of indirect refoulement too. First of all, it's important to notice that Italian Supreme Court seems actually to have chosen ruling opposed opinion, forbidding, denying possibility to invoke Article 17 Dublin 3. According to Italian Supreme Court, the discretionary clause couldn't let the judge checks the respect of the principle of non-refoulement into the decision of administrative unit, Dublin unit of Ministry of Interior. But this approach, if confirmed by Italian Supreme Court, appears, in my opinion, in contrast to Article 27, that ensure a remedy, a review, in fact, as in law. Thus, we know that Article 27 of Dublin Third, which is titled Remedies, states that the applicant shall have the right to an effective remedy in the form of an appeal or a review in fact and in law against a transfer decision before a court of a tribunal. And according to Article 17, W3, by way of derogation from Article 3, each member state may decide to examine on application for international protection lodged with by a third country national or stateless person. May decide to examine. So the Court of Florence question concerned only the case foreseen under Article 18, letter D, namely the situation where the claim in the first member state was definitely refused. We don't check that decision. According to Article 18, obligation of the member state responsible, the member state shall be obliged to take back, under the condition laid down in Article 23, 4, 5, and 9. Let's have a look at the facts of Roma and Florence cases. The factual background to the dispute is very similar. Some Afghan nationals submitted an asylum request in Sweden and Germany, respectively. After their application were definitely rejected, they submitted a second asylum request in Italy, since the Eurodac system revealed that the applicants had previously claimed asylum in another member state. The Italian competent administrative authority ordered their transfer to the competent member state according to the Dublin criteria. The applicants challenged the transfer decision before the referring courts, claiming that following their transfer, the national authorities of the competent member state would have deported them to Afghanistan, where they would have run a real risk of inhuman or degrading treatment. Therefore, they submitted that their transfer was in violation of Article 4 of the Charter and Article 2 and 3 of the European Convention of Human Rights, and invoked the application of discretionary clause set out in Article 17. At last, we are in this situation that Luca Perilli described exactly. The applicant is about to be pushed back as a direct consequence of two decisions, of the decision of the first member state, where he is about to be transferred, and as a consequence of the decision of the second state. I want to remember that with the decision of Dublin Unit, Administrative Office in Italy, Dublin Unit, we move a person physically. We don't move papers, we don't move proceedings, we move people. This decision involves freedom and not only the state competence about asylum. We should agree and be conscious about this concrete situation that concerns a decision that has an impact on a person's freedom. With this in mind, let's now address the different reasoning in the references for preliminary ruling raised by the Court of Florence and Rome. The Court of Rome doubts whether the national judge seized of an action for a remedy towards a transfer decision under Article 27 of the Dublin Regulation, doubts whether the national judge must assess the existence of a risk of indirect refoulement in compliance with Article 4 and 19 of the Charter. The Court of Rome has and shows lots of doubts about it, enhancing mutual trust. On the other hand, the Court of Florence asks if Article 17 doesn't not preclude, but less the national judge seized of an action for a remedy towards a transfer decision under Article 27 of the Dublin Regulation to ensure the protection against the risk of indirect refoulement as a consequence of the transfer to the competent member state. There's an evident, important, profound difference. the discretionary clause is enhanced in Florence decision, where the question is whether the European Union law, less national law, obliged the national court to assert its competence and avoid the risk, if established, of course, of indirect refoulement. In my opinion, Florence Court solution cannot seriously affect the functioning of the Dublin system and the mutual trust principle among the member states, because it relies on a dictionary power accepted by Dublin regulation just under Article 17. Nothing should force us to restrict the use of the discretionary clause just in front of the major risk for the applicant, the risk that European asylum common system is born to avoid. According to the referring Court of Florence, Article 17, less member state, including its judges, free to make use of discretionary clause to avoid pushing back in case of risk. Also when mutual trust would preclude access to an effective remedy towards the risk of indirect pushing back. The Court of Florence reminds that prohibition of refoulement should be respected in any case, according to Article 10.3 Italian Constitution, and according to Italian legal system, Article 19, 1.1 of the Consolidated Immigration Act. Thus, in case of a negative decision of the European Court of Justice, the National Court could or should be forced to seize constitutional Italian court to protect fundamental rights enshrined in Article 10. Moreover, the discretionary clause should make it possible to implement European Union law in compliance with the national constitutional identity and the national constitutional tradition. The referring court invokes the right to asylum enshrined in Article 10.3 of the Italian Constitution, which has, this is very important, a broader scope of application than the international protection defined by European law. In the second Florence preliminary question, is the question that Luca Perilli talked about, so I don't speak about it. At last, discussing mutual trust, we have to consider two different points of view on it. The first one posits that the first member state decision is the only decision admitted about the case. This approach doesn't trust that the second state, with its internal laws, could ensure better respect of non-refoulement. According to the second point of view, trust means that the application of discretionary clause by other member states can guarantee a solution more in line with Charter and European Convention. The second approach leaves some space for concurring remedies. The first approach anchored the system to a minimum level of protection. It cancels the discretionary clause and allows the member state, by choosing the reception member state, to select the state in charge and at last the standard of protection. Under the second approach, by contrast, Article 17 discretionary clause permits the member state, by relying on their domestic law, for instance in Italy, Article 10 I said, to ensure the respect of non-refoulement, although indirectly. In the end, this discretionary clause always lets, in my opinion, each member state the possibility to check, in any case, the actual risk of inhuman or degrading treatment. We also need to consider that the applicant did not choose the state of the first claim, because he cannot travel within Europe by law. More often, European member states choose the first state as the one where to apply. We have two different risks of follow shopping, we talk about. by the applicant after the first decision, but also by the member state according to the agreement, for example, to the agreement of internal redistribution. Of course, the best solution should be an effective common European asylum system where the standard of protection is common to the member state, and this incorporates the principle of non-refoulement, avoiding the risk of indirect refoulement as a consequence of a different decision. But coming back to our case, Germany or Sweden, no, the country that decided the first applicant, Germany and Sweden might question their approach towards Afghanistan's actual insecurity, only if member states will have the possibility to protect seekers by the risk of pushback. And Italy, on the other hand, could change its opinion if it will be able to read and check the German-Sweden decision by relying on Article 17. On the contrary, Germany or Sweden and Italy will go separately in only apparent common asylum European system. And the destiny of Afghan nationals will continue to be decided by the routes of migration, by the agreements of internal redistribution, or mostly by the destiny. The European Court of Justice has now the task to bend Dublin 3 to European Union Charter of Fundamental Rights and to European Convention. I think that it will be possible to bend Dublin 3 without breaking the same. Thank you. Thank you.
Thank you very much, Luca, for sharing the expertise of your court, but also that of the Code of Rome as regards the interpretation of indirect refoulement, and also for staying within the time limit. So we are very lucky that we still have 5 minutes for questions and answers. And I would like to open the floor now for